So we're in the studio today talking with Pace Law Firm senior litigator Alex Faduras. Pace Law Firm has been fighting accident rights since 1980. And you, of course, extensive experience in trial and for the Court of Appeals for Ontario, the Division Court, the Ontario Court of Justice. So you got a big fancy title here. Welcome to the studio.
Well, thank you very much. Over 22 years of practicing law, I guess I've gotten around a little bit.
A few times. Mom must be proud. My son's a lawyer.
Mom and dad.
Exactly. But the lawyers, when people think of a lawyer, do we really need a lawyer? I guess it all depends on the situation. You could be involved in an accident. There could be other things, factors going on. Why would somebody really need a lawyer? When you think, what happened? I was in a car accident. Do I need a lawyer?
Yeah, I think you definitely do need a lawyer, but if I can step back a minute, it's unfortunate that people do need lawyers. Mm-hmm. I tell my friends they'd be better off if you never needed a lawyer or a doctor. The problem is we get sick and we need doctors, and sometimes we have legal issues and we need lawyers in terms of motor vehicle accidents. And so I practice in personal injury,
right? Any
form of personal injury, a slip and fall or a building collapses on you, or unfortunately the greatest level of, the greatest incidents of personal injury usually come from car accidents. And, if you're in a minor fender bender and you're not injured, you probably don't need a lawyer, which is a good thing.
Yeah.
But if you have any type of significant injury, any type of medical treatment is required, any loss of income, any real significant pain and suffering, you unfortunately need a lawyer, because it's only the lawyer that will stand up for you and your rights and will get you, frankly, the compensation that you need. And there's nothing wrong with that. That's how our system works. And the system works on a self-help basis. In other words, the government doesn't step in with a lawyer, or the government doesn't phone up your insurance company and say, pay this gentleman the money. It's a self-help system whereby you have to hire your own legal representative to represent you in that regard and to get what you deserve.
Exactly. Well, you think, I'm in a small car accident. I cut my finger. Go to hospital. hip, they cover the Band-Aid, and maybe a little treatment. I thought, well, what happens after the hospital?
Right. Well, and the problem is, in that situation, maybe you're okay and you're fine and off you go and you get a prescription at the hospital and, in the next couple of days and a week you're fine. You probably really don't need a lawyer, although you may want to consult with one anyway just to make sure that all the property damage is taken care of, etc. But, listen, I have clients who are minorly injured, and I have clients who are what we call catastrophically injured.
Wow.
They need, the catastrophically injured ones, they need 24-hour-a-day care. They need someone to change their catheter, someone to change their diaper, someone to cook for them, someone to be around in case a fire alarm goes off because they are immobile. They need extensive medical treatment. And the problem is once you leave the hospital in the province of Ontario, OHIP fundamentally shuts down.
Really?
It really does, because OHIP doesn't cover chiropractors, doesn't cover physiotherapy, doesn't cover a massage, doesn't cover a lot of medications, doesn't cover a lot of prosthetic devices if that's how injured you are, doesn't pay for a housekeeper to come to your house, other than temporary assistance through CCAC for a number of weeks. It doesn't cover attendance.
It's all the secondary care you don't really think about.
Right, which is unfortunate, but it's very true. Right. And each policy of automobile insurance has coverage not only for what's called third-party liability, which I can explain a bit more, but it also has what are called accident benefits. And accident benefits can pay for, depending if you've bought optional coverage or not, but can pay for a housekeeper to come in and do the housekeeping chores that you once did. Certainly can pay for an attendant to come in and care for you in your house or at a facility. And in some cases, if you're catastrophically impaired, up to $1 million.
I just thought about that, because just recently my car renewal came in, and of course, before you sign, you check out what the coverage is. You figure, my insurance company, they'll cover everything.
Right.
Not always.
No, not always. And the problem is that in September 1st, 2010, the government changed the auto policies.
That's right.
And in my opinion, it was a real giveaway to the insurance companies. And what they did is they reduced the standard coverage through
That's right. We had the
accident
notice of the
benefits.
amounts. Now it's from 50,000 back to 25,000. It was 100,000, it's back to 50,000. They've cut back in all the different areas.
They've cut back tremendously unless you purchase optional benefits or unless you're unlucky enough to be catastrophically impaired. And so to a great extent, and the problem is a lot of people don't quite understand it,
Yeah.
and they see that if they don't pay for the optional benefits, that they save maybe $100, $150, so they don't sign up for the optional benefits. And I think that's unfortunate. The result has been that because these benefits are cut back so much, the insurance companies are paying out less, and their profits are skyrocketing.
Way up, exactly.
So it's unfortunate. That's an unfortunate situation we're in. But the lawyers are always trying to push the envelope, trying to open up new avenues to collect for their clients, trying to expand the definitions of certain of the law to get their clients more money. But the reality is that without a lawyer, if you have any form of real injury, you will be on your own. You'll be at the mercy of an insurance company. And while there are plenty of good and honest adjusters out there who are trying their best, unfortunately, though, they do work for the insurance side of the world. And the lawyer in this case would be solely working for your interest, for the accident victim's interest.
Right.
And that's the only interest that they have.
Because they'll have the minimum, so we can get you this, but they won't go to the full extent.
They
of
certainly
what
may
you
not
could be qualified for.
Right.
You recently had this, I read this in Litigator magazine, that you had this big hard case you filed, which Pace Law Firm actually came out on top. Tell me a little more about that.
Right. Well, thank you. Well, the Litigator is a quarterly magazine put out by the Ontario Trial Lawyers Association, and they were kind enough to ask me to write an article on a recent victory I had. It was called, refer to the case as Parveen and Aviva. And what happened in that case, and I don't want to get too technical, because I really think that lawyers should be a lot more accessible to the public. They talk in lawyer speak, and and they don't seem to be accessible. And a lot of people have this view that there may be they're very expensive or they're aloof.
Right.
And the fact of the matter is, certainly in personal injury, we get paid on a contingency basis, so you don't have to pay anything up front. In fact, you don't. And I don't want to sound like a commercial, but you don't pay anything unless there is a recovery on your behalf.
That's right.
And then a percentage would be charged. There's certainly no upfront consultation fee. So I do think, and I'm sorry, I'm not really answering your question right this second, but I do think that lawyers should be far more accessible.
Right.
If you do have an accident, while it'd be great if you called me, you don't have to. There are many competent personal injury lawyers out there. But you should certainly make a call and get representation. But in any event, back to the case, Mrs. Parveen settled her case for accident benefits
Right.
with Aviva Insurance. And 3 days later, she decided to change her mind. And she wanted more money. And the law says that you can change your mind after 2 days, but you really can't change your mind after that.
Really?
Unless the insurance company didn't provide you with certain notices that they were supposed to give you. And what they are supposed to give you is what's called a settlement disclosure notice, which is a form that's issued by the government. And it's the same form that the government has issued and made insurers use for the last 10 years.
Wow.
And so when Mrs. Parveen came to me and said when she came to the firm and when the file eventually came to me, whereby she was saying she wanted to change her mind after the 3 days, I took out this settlement disclosure notice and the Insurance Act and the law and started analyzing it all. And to my surprise, I realized that this form that every single insurance company was using, because that's the form that the government created and was requiring them to use,
Right.
did not provide the notices that they had to provide, that they were required to provide by the law.
Really?
And if that were correct, Mrs. Parveen would be able to rescind her settlement and ask for more money. And so we ran off to what's called the Financial Services Commission of Ontario, which is a tribunal dealing with these matters. And we won. I convinced an arbitrator that the form was inadequate and Mrs. Parveen should be allowed to rescind. Aviva appealed, and we went off to what's called a director's delegate, and we won again.
Wow.
And so almost immediately after that, the government changed the form, and Mrs. Parveen was allowed to rescind. Now, while that's very good for Mrs. Parveen, and I was quite pleased to represent her and to give her a victory, the greater significance of that case is that anyone since March the 1st, 2002, up until December 31st, 2012, is able to rescind a settlement for accident benefits if they want to, and can ask for more money.
Really?
Yeah. Now I can say though that there's there's two twists, if you will. One is you have to give the original settlement money back, and two, you really have to feel comfortable that you do deserve more money.
Exactly.
It's, you can ask for it, but you may not get more.
Right.
So what I've seen typically is people have settled, maybe they didn't have the best representation originally, a quick and low settlement was reached, and maybe a few years later the client feels hard done by, and they seek out new counsel, and upon review the new counsel says, well, you know what, you actually could have gotten more, you probably should have gotten more, and maybe we can rescind. But again, you're not going to rescind a $20,000 settlement to get $22,000.
Yeah, it's not worth the stretch.
That's really not what it's about. But what you would do, and I have seen this, where the laws change all the time, or sometimes, frankly, people's health conditions change all the time. And so if you were to settle for, well, I recently was a case, I became aware of a case where a gentleman settled for $500,000, which is a significant amount of money, and it indicates a significant amount of injuries. But since then, the law changed. And the law changed whereby maybe he should have settled for $2 million.
Ah.
And so this person is now in the process of rescinding his settlement and claiming the $2 million instead of living with the $500,000.
So it's safe to say now, if you had a settlement and you were thinking, well, that's it, there's no touchbacks, what you got. There is a case where you can go back and revisit. But how long? You mentioned it earlier, it was only 2 days. How are the limitations now? How far back can you go on a settlement?
Well, because this form was used for the last 10 years, since March 1st, 2002, you can go back to that date. So if you settled for accident benefits in Ontario, from March 1st, 2002 until they changed the form on December 31st, 2012, in that 10-year time period, you can
refile.
You can go back. Yep.
Wow. What about a similar thing if you're not happy with the settlement and you want to go apply again? Are the limitations? What should somebody do? Let's say I had an accident, I got paid a chunk of cash, but now I realize, well, I'm not happy with that. What should I do? What's the first step?
Yeah, I mean, again, unfortunately, it always comes back to you have to pick up the phone and call a lawyer.
Right.
And you have to consult with that lawyer, and you should sit down with the lawyer. You should go through your medical file. You should go through your history. You should go through your current needs. You should clearly go through the actual settlement and all the documentation relating to that. And you should discuss very frankly with the lawyer, do you think I really am entitled to more?
Right.
And if you are entitled to a significant amount more than you did receive in the original settlement, and again, here's the kicker though, if you do have the money to pay back, if you have the original settlement money to pay back, then I would recommend you proceed, you rescind the settlement, and you do ask for more.
Wow.
But this is complicated stuff.
Right.
It's not rocket science, but it is, somewhat specialized, and unfortunately, again, you need a lawyer.
What about this kind of angle? What if somebody in the family member is incapacitated, doesn't have the ability to refile, relegate? Does somebody like myself take over, or how do you come into the picture?
Well, that's a bit of a complicated question, because if they're mentally incapacitated, so in other words, if they're not, as we say in the law, if they're not competent to make their own decisions, then under certain laws in our province, next of kin so their brothers or sisters or spouses or children have the right to make health care decisions. Sorry, and you could argue that making a healthcare decision includes getting, coverage and funding for healthcare. Now, if they became incapacitated, if they had a power of attorney prior to becoming mentally incapacitated, then whoever is the attorney through the power of attorney, they again could make all the decisions for them. And if none of the above exists, you may have to apply to the court to set up a substitute decision maker pursuant to the Substitute Decisions Act. And that's a bit more involved and a lot more complicated and more expensive. But again, usually if someone is incapacitated because of a personal injury, which is a terrible situation to be in, but we're talking about a lot of money. We're talking about a lot of need for health care, for rehabilitation, for supervision. So really any expense that is required is probably worthwhile, because at the end of the day, they will get what they deserve in terms of all of this health care and treatment and rehabilitation. And it's unfortunate, but that's the reality.
It's a lot of information to know, and you don't know unless you have a lawyer. If somebody has questions, how can they get in touch with you?
Well, frankly, my direct line is 647-789-1962. Unless I'm in court or at the Financial Services Commission of Ontario, I'm at my desk. And again, there is Pace Law Firm. We have offices in Collingwood. We have offices in Owen Sound, in Etobicoke in Toronto, and in Scarborough in Toronto. So we're quite available, and we are frankly in this community.
Senior litigator, Pace Law Firm. Alex, thanks for coming in.
Thank you very much.